litigation, the courts finally get around to saying, like, oh, look, these subpoenas were fine. And, like, even with all the heightened protection that the president has, the House may still get these documents. But one thing that won't happen, I am almost certain of, is that none of that will be done before November. So, like, the practical effect of this Supreme Court decision is probably going to be that the voters go to the polls in November not knowing whether Donald Trump is colluding with the Russians, not knowing whether there is evidence in these documents showing that he's been helping Russian oligarchs launder money for the last decade.
Well, I guess the good news is that we will have the resolution to these questions by the time Donald Trump Jr. Takes office, or at the very least by the time Barron is president. All right, let's move on to. There were two over the past week and a half. How to put this? I guess religious freedom is how the right would refer to these things. For the rest of us, it would be about the, I guess, second set of rules that is sort of expanding, it feels like, for people who claim they're religious or moral,
right,
for that matter. So let's talk about, one is the ministerial case. The other has to do with an expansion of the rights granted to Hobby Lobby to deny their employees birth control under their health care program. Let's start with the ministerial one. That one seems to be a little bit more technical than sort of like a broad-based principle.
Yeah, so these are really, the ministerial exemption cases are really difficult cases, and there's a great deal at stake in them. So the basic rule is that if you are a minister, if you're a member of the clergy, if you're one of the leaders of your faith, then you do not benefit from civil rights laws. A church can fire its preacher for any reason it wants to. If the church doesn't like the fact that their preacher is black, they can fire the preacher because he is black. And that's what the Supreme Court has said. But there's a lot of uncertainty about who qualifies as a minister, because so in the seminal case at the Supreme Court, where the Supreme Court accepted that there was a ministerial exception, dealt with a teacher. And this was a teacher who taught both secular and religious subjects. She did have a lot of religious training. She did have, I don't know if she was formally ordained, but she the court gave her a title, minister of the school rather gave her a title, minister of the faith. She held herself out as a minister. And so in those circumstances, the court said, yeah, this is enough. This school teacher qualifies as a minister, so she loses her access to civil rights laws. The cases that were argued on Monday involve school teachers, but it's a much more marginal case about whether or not this person qualifies as a minister. So in one case, the woman taught religious subjects out of a workbook for 2 hours a day at a Catholic school. She didn't have any formal religious training. She was classified as a lay teacher by the school. So basically the only thing she did that was in any way ministerial was 2 hours a day. There was a workbook on the Catholic faith, and she taught lessons out of it. And the school is now arguing that's enough. If you do 2 hours a week, spend 2 hours a week teaching religion, you're a minister, and you don't have access to civil rights laws. So, I could go on for a long time about these cases. I think figuring out where to draw the line for who qualifies as a minister and who doesn't qualify as a minister is very hard. And, I'm not entirely sure where to draw it. But I think the court needs to draw a line somewhere, because what worries me about these cases is that, if 2 hours of teaching religion is enough, the Southern Baptist Convention put out a document saying that receptionists should be their job description should say that they are supposed there to answer questions about the faith, because then they could be reclassified as ministers, and then they wouldn't have the benefit of civil rights laws. When I was a camp counselor, when I was 16 years old, twice a week I would lead what we called a devotion. It was like a 10-minute, give a life lesson to the kids and then end it with a prayer. So I spent 20 minutes a week doing devotions. Does that mean that I'm a minister and that I can't sue if they had violated my civil rights? So these are hard because I don't know where the line is, but it's really, really important that the Supreme Court draws a line, or you're going to see lots and lots of people become ministers and the civil rights laws will shrink.
What seems to me to be weird to me in this case is that I would imagine there's a way of resolving this, and it's starts with in their employment contract or agreement that they're called ministers. And it also seems to me that minister has to mean something within the context of their organization in terms and be reflected in terms of pay. Right? So why can't I call all my people ministers?
Right. So what part of what makes it hard is that in religion cases, the court normally warns, it's called entanglement, because of the Establishment Clause, because the government is not supposed to be involved in religion, courts typically say that courts should not be should not judge religious questions. So it's not the job of a court to say whether Jesus is the Son of God. It's not the job of a court to say whether Catholics believe that a particular sacrament is important. It's not the job of a court to say whether two people are validly married within the auspices of a particular faith. So courts are supposed to stay out of answering religious questions. And so part of what makes these cases hard is that the question of who is a leader in your faith, who is a minister, is a pretty quintessentially religious question. But on the other hand, Justice Thomas, Justice Gorsuch both suggested that should be the answer. If you're a religious employer and you say that someone is a minister, then they're a minister. But if that's the law, then it's pretty clear what's going to happen. A bunch of employers are going to say, "Great, everyone's a minister. We don't have to follow civil rights laws."
And this is relevant for things like Catholic hospitals. This is relevant for things. The Epoch Times, owned by a religious organization, right? We could go on and on and on.
And the Catholic hospitals thing came up in the argument. There are a lot of nurses in Catholic hospitals, and some of them are devout Catholics, but the nurses will provide spiritual counseling to a patient who is worried. They will. They may pray with the patient. And so if I'm a nurse at a Catholic hospital and a patient asks me to pray with them and I do it as an act of kindness, does that mean that I've now lost all of my civil rights because I decided to do this kind thing for this person who may be dying? I don't want to diminish how fraught these cases are, because it is true that courts are very bad at making decisions like who qualifies as a minister of the faith. But in this case, the stakes are so high. We're talking about people losing all of their civil rights that, the courts just have to draw a line somewhere.
Right. Okay, now let's just talk about the second religious freedom case, and I know we both got to get going here, but the second one is an expansion. Hobby Lobby decided that if you are a closely held company, which means that you're not necessarily a public company, I guess, or even or depending on how much of your ownership is a function of family maybe or something. I don't know. You can maybe just remind me of what that determination was. But and you're religious, you can then impose your religious values on your employees, at least to the extent that in terms of what you offer them for health insurance can be can basically break the law. You get a special exemption in the law, and you don't have to provide stuff that you find is, religiously unacceptable to you, like birth control, for instance. And I don't know why it can't be expanded for that. Like, because I religiously, have a problem with appendicitis operations. I think like you keep it in there. God wanted you to have an appendix. You keep it in there is what is my attitude. But now they're talking about expanding it to like not just a religious problem, but a moral one. Explain.
Right. So these cases are a little different. So let me explain a bit of the history here, because like there's a lot of complex legal distinctions that matter. So Hobby Lobby involved an Obama administration rule that said that nearly all employers have to include birth control within their employees' health plan. And Hobby Lobby is a private company. It said, well, our owners have a religious objection to several forms of birth control, so we don't want to offer it. And we claim, because that's what our faith says, that we have a right to not provide birth control to our employees. And the Supreme Court agreed with them. And that was significant because up until that point, the court had always said that you couldn't use a religious objection to diminish the rights of someone else. You could often say, like, hey, there's this law that burdens my faith. I don't want to follow it because of the burden on my religion. And frequently the courts would say, you're right, you shouldn't have to follow it. But the limit on that was that you couldn't use your own religious objection to take away a right from a third party. And Hobby Lobby eliminated that. But Hobby Lobby also left open the possibility, well, maybe there could be some other workaround we can do to make sure that these people who work for these religious employers still get birth control. And there was a whole new round of litigation about a workaround, and the court split because Scalia was dead, so they split 4-4 on whether that workaround worked. And then Trump got elected. And when Trump got in, his solution to the problem, his administration's solution to the problem, was just to say, well, the person with the religious objection always wins. So the Trump administration put out a new rule which said that if you have a religious or moral objection to birth control, you can do whatever you want. You do not have to provide birth control to people. You always win. That's what the new rule is.
Is it just birth control, or is it anything?
Just birth control. So if you have a religious objection to birth control is the new rule, then you win, and then then you do not have to provide birth control to your employees. Or if you have a moral objection, which is its own can of worms. So what's interesting about these cases, at least to a law geek like me, is that there are two competing conservative values in tension here. One is that conservatives really like religious liberty, and I think if the Republican justices could pick the rule that they wanted, they would pick the rule that Trump came up with. But on the other hand, the Republican justices really hate the idea of administration officials handing down rules like this. They want to take a bunch of authority away from federal agencies. And there were quite a few questions from conservative justices saying, like, wait a minute, let's set aside the religious question here. I just don't think an agency should be making this call. And so, I still think that the court is likely to side with Trump here, but I'm not entirely certain. And because I think that they might prefer to use this as a vehicle to shrink agency power. And, that opens up its own can of worms, because the reason they want to shrink agency power has nothing to do with birth control, and it has everything to do with preventing a Democratic administration from protecting the environment.
Right.
But, I am less certain after listening to that oral argument how this case is going to come down.
Okay. So lastly, just let me ask you this. Like, why just birth control? Like if we just defer to religion and we don't get involved, like, if we're not going to even like contemplate the idea that we get to say who is and isn't a minister based upon the way that you treat them and the way that they, function as an employee of yours, which seems to me to be a secular dynamic, right? I mean, if you were truly religious, you wouldn't take any money, in my opinion, but that's just my religion. My religion